The Institute for Justice.
The National Law Firm for Liberty.
Hello and welcome to Short Circuit, your podcast on the federal courts of appeal. I'm your host, John Ross, joined today by IJ attorneys Jeff Rose and Rob Piccola. Jeff, let's start things off in the Second Circuit.
Sure, sounds great. Thanks, John. So the Second Circuit issued a decision recently in a case called Federal Defenders versus the Bureau of Prisons. And the nutshell in this case is that a charitable organization that focuses on providing free legal representation to federal prisoners in the New York metropolitan area challenged the decisions of the warden of the Metropolitan Detention Center in Brooklyn in January of 2019, which the defenders, the lawyers, argued basically denied them the ability to provide effective counsel to the inmates of the detention center. And so this is a very interesting case that, frankly, it raises more questions than it answers, but specifically about the right to counsel and whether or not attorneys can assert the Sixth Amendment right to counsel on behalf of the people they represent, or whether or not the Sixth Amendment right to counsel belongs only personally to the inmates themselves.
Jeff, why don't you tell us about the situation in the winter of 2019, that's 2 winters ago, that gave rise to these events?
Sure. There were a series of things that happened in January 2019. Folks probably remember that the federal government shut down for a while. And so when that happened, the warden put the detention center into much reduced hours for access to inmates and things like that until they could iron out the staffing and personnel issues related to the shutdown. Then there was a fire of some kind, and so the warden instituted further rules and restrictions that interfered with access to the defenders. And then the lawyers showed up at another time in January 2019, and there was some kind of altercation or something going on between the prison guards and some people who are in the lobby of the prison. And so collectively, the federal defenders had spent a huge amount of time preparing to meet with their clients and to do the things that you need to do as a lawyer to meet court deadlines and to zealously represent your client. They weren't able to do that. And so they did something extraordinary, which is that they brought suit against the Bureau of Prisons.
Just real quickly, if you remember from the news back then, there was a big protest outside the prison because it wasn't clear that there was even power in the prison during this period of intense cold in New York. So you may remember having seen, it was in the New York Times and everything. Those are the events that we're talking about. Rob, go ahead.
Yeah, and I think it adds some gravity to the situation that we're talking about people awaiting trial, and one can only imagine how terrifying it is to be incarcerated, to have a trial looming, and to then have a sort of crisis of a government shutdown and not have access to your lawyer to provide you both with guidance and some information, frankly, about the outside world.
Jeff?
Yeah, so, it's worth emphasizing that in the pandemic days that we're living through right now, in which everybody's using cell phones and Zoom and all kinds of ways to communicate remotely, that's just not available. And so, the only way for the defenders to prepare a proper defense for their clients is to actually sit down with their clients in person and meet with them. And so, as Rob said a second ago, all of these restrictions, which the defenders argued were both unconstitutional and in violation of federal administrative law, really interfered with their ability to represent their clients effectively.
So there is a lawsuit that the inmates filed as a class action, but that's not this case. This case was filed by the defense attorneys. So tell us about their claims, Jeff.
Sure. So, the most interesting constitutional claim is related to the Sixth Amendment. And so the Sixth Amendment includes the assistance clause, and the right to counsel basically has 5 components. It's that you have a right to choose your counsel, you have a right for counsel to be appointed, you have a right to a conflict-free counsel. In other words, the government can't appoint a prosecutor to defend you. You have the right to effective assistance, and you have the right to represent yourself. Most federal litigation, including this one, is about effective assistance of counsel. In other words, were the lawyers able to do their job? And the thing that's very interesting here is that it raises a question that the courts actually, quite surprisingly, have never answered, or they've answered it to say no in some instances, is whether or not lawyers themselves can assert Sixth Amendment claims on behalf of their clients. Generally speaking, in federal court, you have to bring your own claim. You can't bring claims on behalf of other people. This is all wrapped up in standing and whether or not there's a personal injury and whether or not the court's order will actually solve a problem for you as opposed to somebody else. And so the way the federal defenders approach this is that they brought a claim in equity. And this is something I had never heard before. And what this means is that rather than bring a claim under Section 1983 directly under the Sixth Amendment itself, the defenders essentially invoked the court's ancient equitable powers to do justice, to administer justice as part of the unwritten procedural rules of the English Constitution that stretches back for centuries, well before the United States was founded. And so the question here is whether or not the federal defenders have a sufficient interest in the mistreatment and denial of access to a lawyer of their clients that they can maintain some kind of suit under the inherent powers of the court to address that. And as I said earlier, this case raises more questions than it answers because the Second Circuit says, wow, this is a lot of heavy-duty stuff that the district court never answered. We're going to send it back down. But it's significant that the Second Circuit didn't say, no, this doesn't exist. They said it does. And so the district court is going to have to consider whether or not the particular equitable powers it has, which are rarely examined, apply in this case. Rob, did you want to jump in?
Well, I was curious to get your thoughts, Jeff. Once this has the benefit of a full factual record, I wonder, once they reach this issue, what it could mean for the toolkit of impact litigators who bring constitutional actions all the time like we do here at IJ.
Right. I had never heard of this before, but one of the first things I thought of after reading this case is I should get one of our summer law students to write me a memo on this, and how often it's popped up, so that we can think about how to use it. And, perhaps other folks who are out there reading the case will do the same thing.
Okay. And with that, let's move on to the next case, which is a state case. It comes out of Wisconsin, involving the state's shutdown order, the stay-at-home order. Rob, tell us about the Wisconsin Supreme Court's decision.
Well, like so many states, Wisconsin has responded to the COVID-19 pandemic with a stay-at-home order. This order came from the secretary designee of Wisconsin's health department. And as you can imagine, it was pretty sweeping in its scope. The sort of gist of it was confining people to their homes, forbidding travel, and closing businesses, all under the penalty of prison time if you violate this. Now, interestingly, the Wisconsin legislature stepped in and felt that their prerogative to be the catalyst for these kinds of things was being stepped on by this secretary designee. And they went to the state Supreme Court to essentially get the order knocked out. It was a hotly contested opinion that had much more soaring rhetoric than I think sometimes we're used to, calling on all kinds of classical liberal traditions that informed our founding fathers and the kind of things that we enjoy reading about. But ultimately, there were sort of two parts of the opinion. And in the first part, there was this hair splitting over what is a regulation and what is essentially a rule and what is an order. The reasoning being that if this was a rule that applied to everyone in Wisconsin, essentially a class of people that could be added or subtracted to at any time, then they would have to go through something called the emergency rulemaking procedure. Ah, yes, administrative procedures. We're familiar with those at IJ too, because in our New Jersey baked goods lawsuit right now, in response to our litigation, the state of New Jersey has come forward with regulations to allow our wonderful bakers to bake for profit statewide. Well, we're knee deep in that administrative process right now. And the Wisconsin Supreme Court said to the secretary that she, like the rest of us mere mortals, must go down the labyrinthine corridors of administrative rulemaking in order to make this happen.
Jeff?
So one thing that's interesting about this case is that basically the Secretary of Health said, I issued an order, and if it's an order, everyone has to obey it. And the legislature said, no, you issued a rule. And if you issue a rule, you have to follow these procedural safeguards. And so it all boiled down to what does the word rule mean and what does the word order mean? And it reminded me of the old saw, sometimes attributed to President Lincoln, although perhaps it's apocryphal. But it goes basically, if you call a dog's tail a leg, how many legs does a dog have? Well, the answer isn't 5, the answer is 4, because calling a tail a leg doesn't turn it into a leg. And what the Wisconsin Supreme Court was saying is that, look, you called this an order, and it's true, the statute allows you to issue orders, but the thing you're calling an order is actually a rule because it meets our statutory definition of rule. And so even though you're calling it an order, even though you're calling that tail a leg, that isn't what it is. And a huge amount of constitutional law boils down to this. And one of the things we fight at IJ often is the government's attempt to just define words in a way that ensures that the government wins. And in this particular case, the Wisconsin Supreme Court said, no, we have procedural safeguards. You aren't the governor. You have to follow these procedural safeguards. And the reason why is no matter what you call it, this is an administrative rule.
So Rob talked a bit about all the soaring rhetoric. How careful do you think the court's analysis of whether this was a rule, in fact, actually was?
I thought that the court's soaring rhetoric was more a function of the parties. You had the legislature on the one side, you had the Secretary of Health on the other side, and it's in the context of this world historical event of the pandemic. And so I think the Wisconsin Supreme Court felt that it had to reach rhetorically in order to imbue the opinion with the gravity that the situation warrants. But in some senses, the analysis is quite everyday. The Secretary of Health basically said, hey, this is an order, and I know it's an order because, it's related to this pandemic thing that's happening, and that's going to be temporary because eventually the pandemic will end. And the legislature said, no, it's a rule because it applies to everybody, and there actually isn't a deadline on it, so it's a rule. And so interestingly, the soaring rhetoric about liberty and freedom and everything like that was kind of nice, but it's just icing on the cake. It wasn't really central. I don't know, Rob, what do you think?
Yeah, I think that part of what was really at stake here was having some public examination of what these rules are before they are applied to everyone under penalty of prison time. And it was something that the majority opinion went into great detail about. I mean, the idea that somebody who is the top bureaucrat in the health department can simultaneously make something criminal, subject someone to criminal penalties for violating that rule, and do it all without public comment or involvement with the other branches of government is what was so disturbing. And, there was the really interesting back and forth with the dissent. There was the dissent by Justice Dallett in particular, I thought was actually a little disturbing. I'm just going to quote briefly. It said, relatedly, the majority makes much ado about nothing when bemoaning that Emergency Order 28 allows the executive to arbitrarily define crimes and impose criminal penalties. In fact, for shock value, the majority ties much of its reasoning to the imposition of criminal penalties. Well, yeah. I mean, throwing someone in jail, especially during a pandemic where prisons are one of the places where this disease can wreak the most havoc and spread the fastest, of course, that's going to be the chief concerns. And so to sort of shrug that off, I thought did a disservice to the severity of the consequences that could flow from this order.
I sort of thought that this was like Dirty Harry in real life, right? Like if you watch the old Dirty Harry movie, everybody sort of secretly cheers for Dirty Harry because he gets these scumbag criminals out there, and instead of following all of the rules, he just basically executes them in the street. And we're kind of supposed to feel a little bit bad for that, but we know that Dirty Harry is serving justice. But actually, in the real world, what the Wisconsin Supreme Court is saying is this isn't a Dirty Harry movie. Just because you think that there's some important end that you're serving, and that the validity of that end is undeniable, doesn't mean you get to assert what are essentially kind of dictatorial powers, that these procedural protections matter. And perhaps the procedural protections matter the most precisely when the stakes are highest and the temptation to ignore our liberty is at its most acute.
One of the interesting things about the majority opinion is that they strike down nearly all of the stay-at-home order, but they do sever the portion that says public schools are closed. That gets upheld. And so one of the dissents then says, listen, if you were worried about criminal penalties, you could have just severed the criminal penalties and made this subject to a civil fine, which is also one of the penalties that the order allows for. If you were so concerned about criminal penalties, we didn't need all this rhetoric about tyranny. Just sever it. Does that not strike you as reasonable?
It might have been reasonable if they had done that, but what they did instead, which I think you could also argue is reasonable, is say that it goes back to have some public comment and to go through not normal sort of bread and butter rulemaking, but emergency rulemaking meant for a specific situation like this. There was some debate over how many days getting this off the ground would take, but it sounds like it could be as soon as a 12-day process to get the ball rolling. And the order would only last, if approved, for 150 days, which also seems more appropriate in light of an ever-changing pandemic. And honestly, I think the straw that broke the camel's back for the majority here was actually the fact, not the order that it struck down, but the order that came after it, which said that there would be some sort of vague phasing in of people's access to the things that were cut off before. Again, based on the subjective determination of the health department head. And I think that was a bridge too far for the majority. I think that having that kind of elliptical end to this was not acceptable, and that confining it to the parameters of the rulemaking process would mean that these things would get both a public airing and consideration before being unilaterally imposed, and unilaterally imposed indefinitely. I think the fact that an emergency rule has an automatic sunset is critical for this kind of situation.
Yeah, and I think it's also true that the distinction between criminal and civil is important. Obviously, getting thrown in jail is a serious thing, but it doesn't mean that the consequences of civil rules are not really significant. I mean, if you tell somebody to close their business indefinitely, and that's going to destroy their business, it's going to mean that they can't make their mortgage payments, it's going to mean all of their employees are not going to have income, and that their lives are potentially drastically affected. That's really, really, really serious, and in many respects, as serious to somebody as being put into prison. And so the fact that the majority was taking seriously the consequences that can happen on the civil side and not focusing exclusively on criminal side seems to make a lot of sense to me.
So presumably now the two parties, the legislature and the Department of Health Services, is going to hash this thing out over the course of the next couple of weeks. And in the meantime, everything's just open in Wisconsin. Is that right?
Well, a few things. Your observation is an astute one, Jay Ross, because the opinion itself implies many times that the parties should work together to work something out, and there's sort of language in there hoping that they'll do exactly what you just said. But I think that the bigger picture is yes, when this opinion came down, there were people flocking to bars and doing things like that. But what this what this order from the Supreme Court didn't do is prevent municipalities, including the counties that are home to Milwaukee and Madison, to be able to have their own directives with their own public health rationales for their own stay-at-home orders, which are not affected by this. So, I think this is sort of a theme that's come up in a lot of the COVID-19 litigation, which is how local is the decision making, and maybe a sort of deference to the more local the decision making, the more likely it is to, at least under the kind of test we see here, pass judicial scrutiny.
Okay. Then with that, we'll close off the show. Thank you for listening, and be sure to tune in next time for more judicial engagement.